to go ahead and get started. Welcome to the second HR Roundtable. And I'm Sherry Redmond, the Manager of Human Resources here at MPUA. We have a number of people that are on site here, but we have an even larger group joining us virtually on Teams. Connie Ford will be assisting with monitoring the chat, so if you have questions during the presentation, please feel free to put those in the chat. And then if we could, I'd like to just call the roll, and if you would just put a comment in the chat if you're here, then we'll know if our virtual audience, who's attending, and in case we miss someone on the original registration. Again, I said I'm Sherry Redmond with MPUA. Next to me is our speaker, Stephen Mall, and I'll let the rest of the table go around and introduce themselves, and then we'll go to the virtual chat.
JJ Wiseman with City of Jackson.
Connie Ford, MPUA.
Teresa Seaman, Alliance Water.
Josh Youngblood, MPUA.
Dave Carruthers, City of Clarence.
I'm John Twitty. I work here at MPUA.
All right, and then online we have someone that looks like they called in. If you can identify yourself from the phone number 660-214-2079. Someone joining us just phone only from the number 660.
Sorry, that was probably Hattie Green.
Thank you. Yes, we gotcha. All right, thank you very much. All right, we have Amy on as a guest, Ashton, Barb McCall, Beverly Watson Stewart, Derek Brown. As I read through these, if there is someone that you're using another person's computer, let me know, of course, too. Jill Reckman, we have Megan, Ron Cum, Tara Strain, and I think that's all we have at this point, Sherry, but I'll be watching the participants as they come in.
Thank you, Connie. Well, we knew that marijuana would be a hot topic, so that's why we concentrated this meeting on a presentation called Marijuana in the Workplace. And a good friend of mine that I've known for over 16 years, he looks young on camera, but I've known him a while. He's an experienced attorney with the firm of McMahon Berger in St. Louis. Stephen handles all facets of litigating employment law in the workplace, employment discrimination claims under federal, state, and local laws. He's also involved in all aspects of defending employment discrimination, retaliation, harassment claims, as well as wage and hour disputes and common law claims brought by individuals against employers. He's appeared in state and federal courts and administrative agencies throughout the country on behalf of management. He regularly advises clients on employment-related matters such as personnel policies, employee handbooks, employment contracts, and severance agreements. He's also well-versed on the labor side, including representing management in arbitration, NLRB elections, collective bargaining, strikes and injunctions, and unfair labor practices. He has extensive experience handling issues before the OFCCP, including preparing affirmative action plans, assisting clients with compliance reviews, and compliance with the applicable executive order and regulations. Stephen graduated from the University of California, Davis with your Bachelor in Arts, and then graduated from the University of Missouri Columbia's Law School. He recently made a similar presentation on marijuana in the workplace to the Southwest SHRM chapter in Springfield. Please help me welcome today's speaker, Stephen Mall.
Thank you very much. Appreciate it, Sherry. Appreciate you having me here. As long as everyone can hear me, just throw something at me. I don't know how you're going to do that through the screen, but if you can, let us know. I really appreciate the opportunity to talk to you today about marijuana in the workplace. I know this can be a scary topic, definitely a new topic for most of us. I didn't bring any with me. I've been asked that already a couple of times. I don't have any. Not my thing. So if you're looking for expertise on marijuana itself, you're looking at the wrong person. I don't have much of that. But I hope I can help you work through some issues today regarding marijuana in the workplace. If you have any questions, comments, or anything, please just throw them at me, yell them out, whatever process we've got arranged, because I want this to be as interactive as possible. Because I think the best way to learn through these issues is what you have all experienced or may experience or fear that you may experience in administering these types of issues. So I look forward to it. And again, if you have any questions, just let me know. So a little bit of history. Back in 2018 is when marijuana first reared its head in the state of Missouri. This was through passage of a law regarding medical marijuana. So in 2018, there was no issues regarding recreational, it was only medical. And for the first time in the state of Missouri, this followed several other states across the country, they legalized the cultivation, sale, and use of medical marijuana in the state. But most importantly for us, in terms of employment, there was no protection for individuals. So if you felt that you had been discriminated against for using marijuana because you had a medical marijuana card, you could not sue your employer for discrimination under the original law passed in 2018. In 2022, however, things changed significantly. That's why we're here today. So in 2022, we had Amendment 3. And this was, again, following a lot of states. So being in the Midwest, and I do a lot of work all across the country, as you probably can imagine, things start on the coasts. They start on, New York, Vermont, Washington, D.C., most prevalently California, Oregon, and Washington, and then they move across the state to the Midwest. So as usual, we weren't the last, and we're not the last, but we are far from the first to pass laws regarding marijuana. Illinois is usually one of the first ones as well when it comes to passing pro-employee legislation, pro-plaintiff legislation. But that Mississippi River is very wide, and not a lot crosses the Mississippi when it comes to that type of legislation. So in 2022, they put the vote to the voters of the state of Missouri, and there was a surprising amount of support for the passage of Amendment 3. They got way more signatures than they needed to even put it on the ballot. And when it got on the ballot, it passed overwhelmingly, which I wasn't too surprised at given the amount of momentum it had gotten in advance of the vote, but it was pretty strong in favor. So we're going to talk about the details of that as we go through these.
There is somebody that is typing.
Yep.
And you're obviously a very good typist, but you might mute your phone.
There we go. It's either that or it was bubbles in an aquarium. So Amendment 3, in essence, legalizes the cultivation, sale, and use of recreational marijuana. So that's the big difference from 2018, where before it was just medical, now it's recreational. We're going to talk about most of these things in more detail, but in general, it prohibits, it does not permit, public use. So you can't just be walking outside, smoking it, or ingesting it otherwise. You can't be driving while under the influence of recreational marijuana or medical for that matter. It prohibits use in the workplace, and it prohibits use for individuals under 21. Some of us with kids are probably hearing their disappointment with this, but that is the law. And it's treated basically the same as alcohol. It also established a regulatory framework that's administered by the state regarding taxation, cultivation, and then the registration process, because not only can you now use it, but now you can cultivate it, right, and grow it on your own. So they regulated how that's done and how you can get your registrations and your licenses to do that. So here's the nitty gritty of it. I won't spend too much time on this, but just so you have a little bit of background on what the law provides. There's 144 additional licenses for these micro business facilities. And again, I don't know the details on how it's cultivated, how it's grown, any of that stuff, but the regulatory framework is very detailed on who can grow it, where they can grow it, those types of things, who can sell it, the dispensaries, where they're located, those types of things. One big change from the 2018 rule was regarding the length of time you can have the card. So originally, in 2018, with medical marijuana, you had these cards. And they said, this allows me to ingest marijuana for medicinal purposes. And it was only good for 1 year at first. Well, in 2022, with the passage of the Amendment 3, they extended that now for 3 years. Gives them more time, kind of cuts down just the paperwork, obviously, not having to go every year to get your card renewed. And it also doubled the number of patients that they can provide the cards to. So before a doctor could provide it to X number, now they can provide it to twice as many. Now, local jurisdictions can opt out of allowing this, but it has to go to a vote amongst the members or the people who live in that particular jurisdiction. I don't think that's happened yet, as far as I know, because it's just passed, obviously in November. So I don't think that happened in April, that I heard of, but I guess it could happen in November if it gets enough interest. So we already talked about, with the, oops, I went up, sorry. You got me, whoever told me, I have to go down on the puncher. So why did this pass? Well, one reason people wanted it, but two, big money, right? So, when the lottery passed years and years ago, that was why did we pass the lottery? That's bad, it's gambling. Well, because it raised money, right, for schools. Schools are getting a lot of this money. Well, there's a lot of beneficiaries of the passage of this new law. The taxes that will be charged and assessed on the production and sale of this will be used for various reasons throughout the state. Revenue, and we'll talk about this in just a minute, but for veterans programs are the big beneficiary of this. And that was one of the ways that they got it passed so easily, was the sales pitch was, this is not just going to be providing marijuana to those who need it or who want it, but it's going to be raising a lot of money for individuals who are in need and programs who are in need. And it talks out on the screen about the amount of money that they're projecting will be raised in the initial year or so, well into the millions. It's interesting because, you've got Illinois, who's had it for several years. Then you go to Missouri. I don't think Kansas has it yet. I don't think Oklahoma has it. I may be wrong. I don't think Arkansas, but we still have an opportunity for people who don't live, and maybe they do, I don't know.
What are the regulations for a local city to put a sales tax on, city tax?
They can do that. I don't know what the rate is, but they can do that as another way of raising income.
Well, the reason I asked that, a few neighboring towns around me up there put a 3-cent tax on it, city tax.
I'm pretty sure they can do that, and that's a big, huge potential revenue for those municipalities.
Well, since it's become legal, how long before you start seeing that being sold in packaged liquor stores, along with, convenience stores, cigarettes and alcohol?
I don't think, that would have to require a change to the law, because right now it has to be sold through certain licensed dispensaries, right?
Okay.
So in order for that change to happen, just like everything else, it's a progression. This is step one, or maybe step two. We had step one back in 2018. Now step two is recreational and being licensed to be sold in certain registered licensed dispensaries. Step three, is that going to be the next step? I don't know. That seems like a pretty far step, and it could be several years down the road before that happens. I don't see us going that way anytime soon. I mean, didn't we just get gambling devices, in various locations? That was various steps down the road from first of all, it had to be in a boat, right? You had to have gambling in a boat. Then you don't have to be on a boat anymore. It could be on the shore. Now it's in your local convenience store. So it's a progression. Will it get there? I don't think so. Well, but I've been wrong before. I'm one of those lawyers who will not admit that, doesn't have a problem admitting that they're wrong. So I could be wrong.
Well, when you start talking about significant revenue, the government seems to overlook a lot of things. I remember when riverboat gambling started, major part of the casino was still on land,
right,
but part of it was on the water.
That's right.
And now that's kind of
that's gone. That's out the window. That's correct. So, my point in bringing that up was, other states, the more other states start to get these laws and allow usage, we're going to lose like people from Iowa, people from Kansas, people from Arkansas coming into Missouri to buy it. So I think they're going to take advantage of it while they can. And then once those states pass laws, then the projection of the amount of revenue we're going to get from the sales may decrease a little bit. But for now, I think the state will take advantage of that and, bring people in from other states to purchase the product here.
Channel 4 in Kansas City says you can do a local 3% denning on top of the 6
Yeah, I thought there was
with a vote.
with a vote, right?
Yeah.
Yes, that's one interesting thing about giving presentations now. 10, 15 years ago, you could say whatever you wanted to, and people couldn't look it up with their phones to tell if you were right or wrong. Now, it's like, are you sure? Because this guy just says this.
Stephen, I'm just trying to help.
I know. That's one thing where I appreciate it, when you give me good information. But when you say that though, I get a lot of calls from clients and they'll say, so can I do this? And before you answer, here's the information I already got on the internet. So just to prove whether you're right or wrong. I'm just like, okay, well, why are you calling me if you already have the information? So who's the beneficiaries of the revenues that we were just talking about? We're assessing taxes and levies on this. So we got the veterans programs, we have legal services for low-income residents and other nonprofit organizations that will be designated as we get through this. They anticipate a lot of money being able to be raised for these organizations as a result of all the sales, and this is obviously one of the benefits. Another big thing is the expungement of criminal records. So another tool that was used to try to get this passed was, we're going to take people who have already been arrested and or convicted of marijuana offenses. We're going to allow them to implement a process where they can go to court and say, I want my conviction overturned or expunged from my record so that it no longer exists. And why is that relevant to employers? Well, most employers, some employers, were doing background checks, right? And you do background checks on their usage of criminal convictions, and that would show up. And employers would use that as a reason to reject employment, right? Because they have a criminal record a criminal conviction on their record. Well, now, if the arrest, plea, or conviction is related to a marijuana offense, unless it's one of the three on the screen, you can follow this process and go to court and get it expunged. Now, some of the taxes that are being collected from this and the money that's being raised is being directed toward the court system so they can develop this process and allow people who have been convicted to, you go to court, you file some paperwork, you go to the court, and after a period of time, it's expunged. So now when we do these criminal background checks, it's not going to show up anymore. Okay. However, it does not apply if the marijuana conviction was related to violence, delivery or distribution to minors, or operation of a vehicle under the influence. So if it's one of those three, that will still show up and you cannot get that expunged. But if it's regarding just regular sale or usage or distribution, other than to minors, that can be expunged from that record. And I'm sure there'll be some discussion about that as we go forward. So not only did they legalize recreational marijuana usage, they made some changes to the medical marijuana as well. So before, only licensed physicians could issue the marijuana cards, medical marijuana cards. Now a nurse practitioner can recommend use, broadening the scope of individuals who can authorize a patient to have the card. And again, I already talked about the fact that they've lengthened them from 1 year to 3 years. Most importantly, though, for employers, is the employment protections to individuals. So when you're granted a medical marijuana card, you have certain protections in your employment. You can bring a cause of action. In 2018, they said no cause of action, right? We already talked about that. You couldn't sue your employer for being fired or being discriminated against because you had a medical marijuana card, right? Couldn't do that. So what employers basically did was they said, if you have a medical marijuana card and you present it to your employer and says, yeah, I tested positive, but here's my card. Employers basically said, okay, thank you. We're going to go and look at that as if it's a disability. So when you're taking a medical marijuana card, presumably you're taking it because you have a medical condition, which would be a disability, right? Under the Missouri Human Rights Act. Missouri Human Rights Act is the state law that prohibits discrimination against individuals because of their race, sex, age, religion, and disability. So if you're taking this drug to address your disability, then you would have to engage in that process and determine whether or not the individual is entitled to a reasonable accommodation, just like they're entitled to a reasonable accommodation for any type of disability. And what are they asking for? They're asking to be able to come to work, and if they're test positive for marijuana, they're saying, excuse me for that, because I have a medical marijuana card. And so you have to engage in that interactive process, just like you do with any disability, to determine whether or not it's reasonable for us to accommodate you and test positive for marijuana. And then we have a whole list of factors that we're going to talk about later on. So would that be reasonable under the circumstances to allow the individual to test positive and to be, maybe not necessarily under the influence, but have it in their system? And can they perform the essential functions of their job with that in their system?
And that's the $64 question.
Yes.
For most of the people here, because an awful lot of these folks have linemen, they have water construction folks, they have water treatment, wastewater treatment folks. And if you're under the influence, is one thing if it's in your system,
right?
But not under the influence, of course.
Right. And that's where we're at.
Yeah.
So, and that's where the discussion is going to go, because in 2022, they basically said you cannot discriminate against individuals because they have a card. Okay? And it's expressly in the law. And that includes hiring, termination, or any term or condition of employment. Now, does that mean you have to let them come to work high? No. And we're going to talk about that, okay? Doesn't mean you have to let them use on the job. It doesn't mean a lot of things.
Where my rock and hard spot comes, I also operate a high-pressure natural gas pipeline, and we fall under PHMSA and DOT rules. So
you're there. That's about 3 slides away.
okay.
Be quiet for a minute, Dan.
I want him to talk, because the more he talks, the less I have to talk. People get tired of hearing me talk. I turned it upside down. Let's go this way. Whew. Okay. So, there you go. It was 1 slide away. So, the prohibition against discrimination. So, right, if I have a medical marijuana card, you can't discriminate against me because I have that card. But that does not apply under these 4 scenarios. Number 1, if you're a federal contractor or a subcontractor. Why? Because according to the federal law, marijuana is still illegal, right? This is just under the state law. Under Missouri law, it's no longer illegal under certain circumstances. But under federal law, it's still unlawful for now. Is that ever going to change? Every year they talk about it. Every session they talk about it. They try to pass federal legislation legalizing marijuana, and it just kind of stops. Just like everything in Washington, D.C., nothing happens, right? Unless it's at an agency level, nothing happens in Washington, D.C. anymore. Legislation just does not happen. Unless it's, 2020 with COVID, EFMLA and the CARES Act and all that good stuff, unless it's something like that, nothing happens in Washington anymore, especially when it comes to employment law. There's no leave laws being passed, there's no marijuana legislation being passed, nothing's happening. But for right now, it's still unlawful. So therefore, if you're a federal contractor, a federal subcontractor, or if as a result of allowing this, you would lose federal funds pursuant to your agreement with whatever agency you're dealing with, there's no prohibition against discrimination. An individual cannot be under the influence in violation of your company's policy. So what's the key there? Have a policy. Have a policy that says you cannot be under the influence of marijuana at work. If you have that policy and an employee shows up and you test them, or if they show up and they're under the influence, you can terminate them. What does under the influence mean? We'll talk about that. If they test positive and the employer establishes they used, possessed, or were under the influence during working hours, then you can let them go. Or if they hold the, quote, safety sensitive type of position. We're going to talk about that in more detail, but that's kind of, I know that's a big part of why we're here today. And I know you want me to give you the final answer on what that means. And I may run out here real quickly before you pin me down, because there is no one answer. But as a lawyer, I get to say it depends. And that's my favorite answer. I never have to answer a question, because I can always just say it depends on the facts and circumstances. So I'm going to stand to that, but we'll talk in more detail. All right. So what is a safety sensitive position? They have the responsibility for their own safety and the safety of others. Clearly, it covers certain jobs. You know, if they're covered by DOT safety rules, it's going to be a safety-sensitive position. And this varies from industry to industry, job to job, location to location, employer to employer. You know, there is no one quote definition. You can't go to the definition book and look it up and say that's a safety-sensitive position. I think you can apply certain guidelines and certain rules. You know, for example, if you're operating a piece of machinery and if under the influence of marijuana, you were to do something that caused injury to you or to someone else, arguably that could be a safety sensitive position. So some employers are saying everything in my whole plant is safety sensitive. Will the EEOC or will the state or will the federal case law agree with you? Probably not. You know, because if you work, I do a lot of manufacturing, represent a lot of manufacturing companies. And there's one large one, they have 1,500 employees under one roof, and they're doing a lot of fabrication, assembly, painting, a lot of stuff. You know, any one of those pieces of equipment, if they're not operated correctly, could cause problems. That's why they have to wear, one of the places I represent, they have to wear arm sleeves because they have metal shavings, they have to wear goggles, they have to wear helmets, you know, they have to wear protective smocks. You know, if you're required to wear that type of PPE, personal protective equipment, you're probably working in a safety sensitive position, such that if you are under the influence or even somewhat less than under the influence, and you do something stupid because of that, and you could harm yourself or others, that's going to be a safety sensitive position. But then on the other hand, if in your facility, this 1,500 person facility, there is an office like we're in here, and it's a local HR office, and they're in the facility, but they're in their own little room and they're just on a keyboard all day, you know, entering forms and all that stuff HR does. If they hit the wrong button on the computer, is that going to harm anybody, or is that a safety sensitive position? Well, they're in the facility, but they're probably not going to be deemed a safety sensitive position, probably. And even though they could say, well, the minute I walk out into that hallway, I have to put my helmet on or I have to put my safety goggles on because I'm where there's other things going on. But my position itself probably is not going to be a safety sensitive position. So it's very fact intensive, and I hate to say it, but it does depend. It does depend on who the person is, what they're doing, where they're located. But to get back to your question earlier about the line people and those types of things, I don't see any way anyone could argue those are not safety sensitive positions. I mean, they're dealing with electricity and stuff that could kill them instantly, right? If they did the wrong thing. And I would assume a lot of those positions are regulated by either the state or the federal law in terms of safety issues under OSHA, under the state safety, any type of state safety guidelines. So I don't think that there's any argument that could be made that positions such as that would not be safety sensitive.
Certainly the natural gas systems that are governed by DOT rules, I don't think there'd be any question. Most of our members are not subject to OSHA because they are municipal utilities. But and probably not any, probably not even any specific lineman, wastewater treatment operator, those kind of folks, probably not governed by any sort of state or federal statute. But if you do something wrong and you're down in a ditch installing a water line, it caves in,
right? You're
dead. A line worker, obviously subject to high voltage.
Right.
So I'd say the natural gas folks who are under DOT, certainly no question about that, but I would sure think that other utility occupations, just logic would say.
Well, and those that have a CDL too,
Yeah,
obviously.
a CDL
Your street
would be,
department,
yes.
your parks department,
Yeah.
they would all.
Missouri Public Service Commission, I have to have my secretaries in the random draw. with
For
all
drug
the
testing?
workers. Drug testing.
Yep.
And I said, but they're in the office. Here's the thing. They may take a gas complaint, I smell gas call. What if they write the wrong address down? You know, get the numbers transposed or whatever. It's sensitive.
Yep.
So here's the thing, whatever decision you make, you're going to have to be able to defend that decision. Because if you decide, I'm going to treat this person as in a safety sensitive role, and so I'm going to say, I don't care if you've got a card or not, whatever the case is, I'm going to fire you because you tested positive, then you have to be able to prepared to defend that decision. And here's what I'm going to rely upon: what they do, where they work, who they're dealing with, what would happen if they made an error in their decision, those types of things. And then you have to be able to defend that argument before the agency or before a court if it gets sued, those types of things. We're still
Go ahead.
we're still really early in this process,
Yeah.
right? I mean, this got passed in November, so it's going to take a while for these cases to get up to the courts and then to get to the Court of Appeals and then to the Supreme Court. I mean, that takes years. So before we get some actual some precedent where we can say, this is where the courts are going, we can look at other states. Other states' laws are drafted differently. Some may be a lot more pro-worker, a lot more pro-employee than others. So we can't necessarily rely on those. You've got to wait for what the Missouri courts are going to say. Go ahead.
Stephen, in the case of drug testing, is there any acuity levels in drug tests that would say, yes, there is THC in that test, but it's 5 days old, as opposed to a day old? Are you going to get there?
We're going to get there.
Okay, good.
But your answer is.
I don't know the answer.
Your answer is, my answer to that is no, but if you find out and you develop that test, let me know, because we will be bazillionaires.
Yeah.
Okay?
Yeah.
That's right.
And then just closing that loop on that last discussion, Beverly, you had typed in, what if they control the city water supply? They did not have CDLs or wear PPE, et cetera. So I think in summary, your thing was, look at how you're going to do this in court into that discussion. Beverly, did you have anything that you wanted to add on that after you heard the discussion? Go ahead, Stephen.
Well, I think that, one thing I heard, and I think that question came to my mind, is someone has control over these services, public water supply or electricity or gas or whatever. If they're not in control of their faculties, they can make a decision that says, oh my God, they're going to, I don't know. I don't know what people do.
Well, over-chlorinate.
Right, they put
water
something in there they shouldn't
from a
put in there or whatever. Right.
Over-fluoridate, whatever the case might be.
Right, and then you've got, Flint, Michigan, where you can't drink the water for weeks, So, yeah, I think you can make the argument. Now, a smart plaintiff's lawyer will say, oh, come on, and argue it just the opposite way. So, again, this is still fertile soil that needs to be cultivated to determine whether or not, where this is going to go, right? What's more important, protect the employee's right and their job, or protecting the public? And that's where the discussion of reasonable accommodation comes in. And we'll talk about that as we go.
So would it be beneficial to the communities to just go ahead and write up those policies and what positions they're considering?
Yes. I think you should have a clear understanding of which positions you think are going to be safety sensitive, and then share them with your management team, or give me a call, or Sherry or whatever, and we can certainly discuss it and go over it and say, well, I think that one you're probably pushing it a little bit, but this shouldn't even be an issue until it becomes an issue, right? If you plan ahead of time and everyone's just doing their job and coming to work and they're not high or not on drugs, on miracle marijuana, but it's coming. It's just more and more popular.
So Beverly wrote, no, we've reviewed all the positions previously and they are considered safety sensitive. However, I just wanted his review, so thank you. But it sounds like Josh made a good point there as far as maybe starting to look at some of those
Absolutely.
that were safety sensitive, and maybe look at those classifications of those job positions and how you're labeling them.
Yeah.
Okay.
Just like with any presentation that I do, why are you doing this? To be prepared. You're doing this before you get sued. You're doing this before something happens. An ounce of prevention is a pound of cure, whatever it is.
And we also heard, because been to several of these discussions, that you have to put those in the job description too, that it is safety sensitive. Is that correct?
Do you have to?
I've heard you have to. Now, that's what I've heard, that it has to be in the job description.
It certainly helps to defend a claim, because you could say, look, Hal, you knew that you were in a safety sensitive position. And it certainly puts you in a better position to defend a claim if they knew ahead of time, well, maybe I shouldn't, or maybe I should tell my employer ahead of time that I've got this card and not wait until after I get tested, that sort of thing. So that way they knew, hey, I'm in a safety sensitive position. I know ahead of time that if I get tested, I may be not protected.
Well, that's the whole thing with, if you put in the job description and then if I'm hiring someone for that, I let them know right up front, hey, this is a safety sensitive
Right.
position. You cannot have marijuana in your system.
Right.
You can't have any drugs in your system. So
Right.
if you test positive, you will be fired.
Yeah, I again, is there a law saying you have to do it? No, but it's much better to have it than not. So recreational marijuana, what protections do employees have? None. You have no right, if you're just smoking on a weekend and then you come to work and you test positive, you have no protections against discrimination. Not required as an employer to allow employees to come to work having used marijuana. You can prohibit the use, sale, and possession of marijuana in the workplace, just same as alcohol or any type of drugs, illegal drugs. You can prohibit employees from being under the influence while on working time, just like you can prohibit employees from being drunk on working time. And you can refuse to hire, discipline, discharge, or take any other action against individuals who are deemed to be under the influence. So this is all regarding recreational, recall. This is not medical, this is all recreational. So it doesn't give individuals rights that they otherwise didn't have before. So what is under the influence? Of course, they didn't define it in either Amendment 2 or Amendment 3. And it depends. And this one, it really does depend. I'm just not dodging the answer. It does depend on the person. I mean, what I could, tolerate could be a lot different than what someone else tolerates. I mean, I tell you right now, I can tolerate 0.00001 because I have no experience with it. Someone else could probably, drive a forklift. Don't let them do it. I'm just saying. And the testing issue that was brought up earlier, it's not definitive because you cannot determine with the current testing that is out there when they took it, how much they took it, how much they took, what type, well, probably what type, but they can't do that type of specific testing because it's just not progressed in terms of the technology. So what do? I think you've probably heard this term before. If you've been in any HR training, especially with Sherry, train. Train your managers, train your supervisors on how to detect what an individual's status is in terms of under the influence or not. So what types of things can you look for? Oh, not there yet. If anyone has a union, I put this in there just in case. If anyone has a union at their facility, there may be provisions in the collective bargaining agreement that you have with them or the memorandum of agreement that talks about drug testing, that talks about the use of drugs in the workplace and testing positive or not, or under the influence. Just stick with those policies and rely upon those. Hopefully they're pretty good policies and provisions in the collective bargaining agreement. But just in case you have that, I don't know if anyone does, but if they do, keep that in mind. So what can you put in your policy? I didn't bring an actual policy, but these are suggestions you can put in your policy. And if you have a policy, you want me to take a look at it, please send it over. I'll be happy to take a look at it, or I'll be happy to develop one with you. You can't prohibit the use of any alcohol, illegal drugs, or other controlled substances of any kind, legal or illegal, on company property, in company vehicles, or while on company equipment. You have every right to do that. It's your business. It's your company. It's your organization. You can limit the use and possession, distribution, sale, any of that on your property. No question. You can prohibit the illegal and unauthorized use of prescription drugs. So even though medical marijuana is prescribed, if someone is using it illegally or it's not authorized, you can prohibit that usage. You can prohibit the intentional misuse or abuse of prescription medications. And you can prohibit any employee from being under the influence of anything. Why? Because that's not safe. It's not something you have to tolerate. So if someone is under the influence, you can say, look, we're not going to allow that in the workplace. When this first came out, I'm sure some employees were thinking, oh, I can show up to work in any condition I want and there's nothing they can do about it. That's not the case. And I don't think you can do that anywhere. Well, maybe some places in California, but we're not talking about California. So that's the things that you can still put in your policy. What else? Tell them in advance, and what I always tell you in every policy you ever have regarding employees, put them on notice that if they violate the policy, here's what's going to happen to you. Discharge, suspension, investigation, whatever the case is. But you always want to put your employees on notice of the ramifications of their actions if they're caught doing something they shouldn't be doing, which is a violation of the law or company policy. It's a violation of the company policy if they're using lawful medical marijuana or recreational marijuana if it's in their system and they are impaired. You can put that in your policy, absolutely. If they're impaired and you can tell that they're impaired, that's a violation of your policy. Cannot impact the safe and efficient performance of their job, that should be self-explanatory. If they're under the influence of any substance, you can require them to tell their supervisor. Are they going to do it? Probably not, but you can get them for not telling their supervisor that they were under the influence if they knew that they were. That one doesn't happen very often because most employees won't volunteer it, but you can still put that in your policy. And here's the last one we were just talking about. In advance, evaluate which positions are safety sensitive and which ones are not. So as we already talked about, be proactive, go through each of your job descriptions and determine which ones you think are safety sensitive.
So why do you have both in all capital?
Maybe my thumb stuck on the caps lock button, I don't know. Using prescribed medical marijuana or legal marijuana or other hemp-related products causes both the presence and the impairment. Because just because it's present in your system, if you have medical marijuana, it's not going to be under the influence, right? So I think what that's talking about is, yeah, it's in your system, but I took it 30 days ago, 29, 28, 27 days ago. That's not impairing my job performance. I'm not under the influence. So I think it needs to be both if it's medical marijuana.
But it doesn't matter if they're safety sensitive, right?
If they're safety sensitive, no. Right. So if you have a reasonable suspicion drug testing policy, describe what it is. And we're going to have a couple of, I think it's the next one, of things to look out for. But make sure that that process is in your policy so that employees are aware of it and can, at least they can say, hey, I knew about it and I still violated it. Again, train your managers and supervisors on how to observe and watch for signs that people are under the influence and that would give them reasonable suspicion to believe that they need to test an employee. And then notify HR. I prefer to have HR be the one to send them for the drug test, not have a manager or supervisor. But if you have a policy that says a senior management official can send them, then make sure they're notifying HR that they're being sent for that test. Now, if they're working nights, obviously, they may just go ahead and send them and just whatever. But I prefer that HR be the one who sends them and not necessarily a supervisor or manager. I was right. The next slide talks about things to watch out for. This is not based on personal experience. This is based on research and review of what we think are most common visual expressions that someone may be under the influence. Drowsiness, bloodshot eyes, slurred incoherent speech, alcohol in breath or odor of drugs. All of these types of things you can rely upon. The more of these you can check off, the better, to establish that a person may be under the influence and can be subject to reasonable suspicion drug testing. If you have the last one, that's probably the best one you can have, is possession, obviously. What is it? Possession is 9/10 of the law. So I would think that that would be the best one to rely upon because it's not subjective. It's pretty objective. They've got it on their system. So therefore, I think we're going to test them. But if they're possessing it and they don't have a card, you've already got a policy that prohibits possession of it in your workplace. So that should be in and of itself enough just to fire them on the spot and not even bother with testing them. But again, that depends on what your policy says. So some of these, bloodshot eyes. Well, maybe you just didn't sleep last night. You got a brand new baby at home and they're crying all night. You didn't get any sleep and you just got the bloodshot eyes because you're just exhausted, right? Or you went swimming in a pool yesterday, you didn't wear your goggles and the chlorine's in your eyes and you got bloodshot eyes. So are you going to take a risk just on that one? Yeah, probably not. I mean, the person's acting normal, they're not engaging in any unusual activity, they just got bloodshot eyes. Are you going to really test them for that? Probably not. That's why I say the more of these you can check off, the better to determine whether or not you've got enough information that you think reasonable suspicion testing should occur. Some of these are more obvious than others. Obviously, the odor of drugs. My wife is a teacher at a community college, and she all of a sudden can smell it anymore now because the kids will walk in with it, having just smoked it or whatever, and she can smell. I still can't smell it. I haven't been around it enough to know. But she can smell it right away. We were down at, I forget where we were, downtown St. Louis somewhere. And we walked by, and someone walked by, she says, oh my God, because she can't stand the smell of it. And she noticed it right away. So apparently it's very distinct, and you can, once you know it, you know it. So the fourth bullet point should be the one that really kicks it into gear in terms of whether or not you think you have reasonable suspicion. Other ones just could be because, like, you know, say they're sick and you get the vertigo and you're stumbling or you're tripping a little bit, you know. So poor physical coordination, again, in and of itself, is that enough? Probably not. But when you combine it with the other things, that could be sufficient. So I would put those in your policy as well, and especially in your training. So getting to drug testing. So this is largely regulated by state law. So every state has their own drug testing policies. Missouri doesn't really place any limits on when people can test, particularly pre-employment. You can pretty much do whatever you want. You can test or not test. I can tell you right now that fewer employers are testing.
Fewer are.
Yeah, because, well, we all know why. You can't find anybody to work, right? Employees are hard to find. Qualified employees are hard to find, and just employees. So people are just saying, look, if I don't hire anybody because they have marijuana in their system, I'm not going to hire anybody. Particularly in certain industries. It may not be applicable to your industry, but in certain industries, you just can't, because you would never have anybody apply, and you'd never be able to hire anybody because everyone would fail. So that's the status. That's where we are these days, folks. So a lot of employers just say, we're not going to test for that particular drug. We're still going to do the other panel. We're going to do the rest of the panel, but we're going to take marijuana off the list. That's your decision. Again, if it's safety sensitive, I wouldn't do that. But if it's not safety sensitive, and if you're in dire need of employees, be prepared to say, well, we're going to excuse that one, or we're not going to put it on there. Missouri's reasonable suspicion, we already gone over that. Random, you can do random, you can do post-accident. The only thing with post-accident is generally what we've been recommending is OSHA came out with a rule. I know OSHA coverage is questionable, but OSHA came out with a rule several years ago that said post-accident, employers used to say post-accident, test automatically, right? Accident, injury, automatically test. Well, then OSHA came out and said, only if you have reasonable suspicion to believe that drugs or alcohol directly caused that accident, could you then test based on post-accident. Well, they backed off that quite a bit. And now it's a little less of a standard. They still want you to think that maybe it caused or maybe it was a factor in the accident or the injury. You can't just automatically test post-accident. I still think that you arguably can, but it's better if you have some thought that, hey, maybe alcohol or drugs played a role in the decision, then we're going to test. And if they get injured and they go to a doctor, they're probably going to be tested anyway, because that's just what most clinics do these days. But the 4 areas of testing are up there: pre-employment, reasonable suspicion, random, and post-accident. Missouri's pretty much do whatever you want, and that has not changed. And here's the philosophical question: should you continue to do them? Well, obviously you have to. if you're required by law. So if we're a federal contractor and you have a Drug-Free Workplace Act policy, now, just because you have a Drug-Free Workplace Act policy doesn't mean you have to test, but you can. And some will require you. So if you're covered by DOT, if you have a safety sensitive position, and there's a different definition of safety sensitive on there. Any job that requires duties or tasks that could affect the safety or health of employees performing the task or others. Pretty similar to what we talked about earlier. Again, but very vague, very broad. But to the extent you have required by federal law, or even some state laws may require you to drug test, then you have to follow those laws. But if you're not, and you don't have a safety sensitive position, and you don't have a CDL requirement or a DOT requirement, are you going to drug test? Are there enough clean employees out there, to fill your vacancies such that you can have enough available labor to fill the jobs? I don't know. I'm not on the front lines hiring folks. You guys are more than I am. From what I'm hearing, it's still really hard to find employees willing to work. And once you hire them, it's hard to keep them for more than a few months, right? The turnover rate in some industries is 100% every 6 months. It's just insane. And it's certain jobs, it's in your industry, it might be the same way. I don't know. But what point are you willing to not let it slide, but are you willing to accept that some employees in certain positions, they may have taken marijuana within the last 30 days of their interview, right? And that's just the way it is. So that's the subjective, that's the philosophical argument that employers are having to deal with these days. There's really no right or wrong answers unless you're required by federal or state law to drug test. Then there's a clear yes or no answer. But if you're not, then you've just got to do what's best for your own industry, your own facility, in your location, in your part of the state.
So if a utility serves like Fort Leonard Wood, they're just a service contractor, right? They're not a contracted entity of the federal government.
You would have to look at the details of a specific contract you have with the Department of Defense. I assume that's who it would be with.
Yeah.
And see what that specific language is, and deal with them on a specific basis. I wouldn't want to speculate on what that says.
Yeah, I'm just throwing Fort Leonard
Sure.
Wood out there, but I'm sure there's other federal,
absolutely.
VA hospital here in Columbia, other
Right.
things like that. So thank you.
But you would have to look at the contract.
Okay.
Or service provider, provision, language. So here's the question that was asked earlier about the testing and what can they find or can't they find. If you come up with the technology to determine when they took it, then you're going to be rich. It's being developed. There's rumors out there it's trying to get developed. I'm sure there's a lot of people out there people a lot smarter than me, trying to develop that technology. But as of right now, that doesn't exist. So you get a positive test. What do you do with that? Does that mean they were under influence? Maybe not. Again, because it stays in your system for so long. You may have taken it so long ago that you're no longer under the influence. I don't know how long it lasts. I don't know how long you're under the influence when you take it. I personally don't know. So if you smoke a whole bunch of it over the weekend, is it still going to be in your system? Absolutely, when you go back to work on Monday. But are you still under the influence? It's hard to tell. And I'm sorry I can't give you a better answer on that. I wish I could. I wish I could say this level, this amount, this timing, and it's just not a black and white answer. They come to work and they show those types of characteristics that we talked about a couple slides ago, send them for testing, it comes back positive. If you've got a policy that says test positive, you're out, then you can enforce that policy, right? Because it's recreational. Do whatever you want.
With the medical card?
With the medical card, that's when it comes different because they're allowed to take it. They've got this accommodation. Then the conversation is, do we have to accommodate their usage? Remember, as we talked about, the MHRA, Missouri Human Rights Act, requires employers to accommodate individuals with disabilities, right? Just like if they have any other type of disability. So they're taking this medical marijuana because they have a disability or a medical condition. And they test positive, or they come to work and they tell you, if they're smart, they would tell you, in my opinion, because they get protection, right? Because now they're protected. You can't discriminate against me because I had this. And don't want to know usually. Sometimes you don't want to know if people have a disability because you can make a decision regarding their employment. Well, I didn't know they had a disability, so you can't sue me for disability discrimination if I didn't know. So if I'm an individual who has a disability, and someone who is taking medical marijuana, if I was me, I would tell my employer, so that way I'm protected. Or at least they can't fire me for that. I've got to defend. I can sue them for discrimination based on a disability and/or under the Amendment 3. So if I test positive and I've got a medical marijuana card, and the employer says, well, I can't employ you in that position because it's safety sensitive, then you as the employee can say, well, I can do that job, I can do that job, I can do that job. Then you have to engage in what's called the interactive process. You familiar with that? All right. You engage in the interactive process and say, well, Sherry's already doing that job, Stephen's already doing that job, and she's already doing that job. So that's not available for you. If we have any open and available positions for which you're qualified, you certainly can apply for that job, right? Same analysis you do for any other type of disability accommodation discussion.
Well, and you also need to look at your policy too, because if my former employer, the policy said you had to test 0 on marijuana to be able to come back to work, to return to work. And so the half-life of marijuana was arguably longer than, if somebody's under the influence of alcohol, they can sober up and probably be back to work within a day or two. Under marijuana, we had one person who was out over 30 days because they still were above the 50 nanogram or the 15 minimum nanogram limit to be able to return to work. So can we do without an employee that long? Some of you smaller municipalities, you can't just hold the job forever. So you have to make sure your policy is something you can live with, because you will have to follow that policy if they choose to.
That's right. Right. So, if you can accommodate them by putting them in a different position, putting them on a leave, maybe they have a leave of absence policy that you can implement. It may not be paid, but they can take a leave of absence until they get it out of their system. But if they're medical marijuana, they're probably not going to get it out of their system. So then the decision is, am I going to work at this employer knowing I had this condition and knowing I have to take medical marijuana? Maybe you should consider other types of treatment. Maybe something else could work for you. But to work here, we have this policy, we're going to enforce it. All right. But most of that stuff. We already talked about the fact that just because you're positive doesn't mean that you're under the influence. Again, it depends on the timing. What is the policy required? Just like Sherry talked about, if your policy says 0 tolerance, then you've got to enforce your policy. And we've already talked about the last bullet point, which I think is kind of the ending theme here. We don't care, just don't come to work high or under the influence. That's what some employers are saying. You guys, you don't have to do that. You don't have to do that certainly for all your positions, but that may be something you're doing, considering if you're in dire need of employees. I don't know, maybe you've got a good workforce, you've got a good source of pool of potential applicants, and you don't need to be worried about that. But that's what some employers are doing. Workers' comp, there are still some protections in the workers' comp for employers. So if an employee gets injured in the workplace, the benefits can be reduced by 50% if it was sustained in conjunction with the use of alcohol or non-prescribed controlled drugs. If the use of alcohol or non-prescribed controlled drugs in violation of the policy is the cause or proximate cause of the injury, then benefits can be forfeited. So that's still in effect as far as workers' comp coverage. Those are still, that law is still in effect. If you do drug tests, make sure they're confidential. They're kept confidential. Make sure they're kept in a separate file. I would not put them in a personnel file. I would put them in a medical records file, medical file. That doesn't get shown to everybody who would have access to employment files. But if a manager or supervisor needs to know that an individual, for example, has a medical marijuana card, and they need to know that so that they're aware of restrictions that they may have, then you can share that with that manager or supervisor. And of course, the first aid personnel, if they need to be made aware, so that for whatever reason, you can tell them as well. All right, let's talk about questions. Holy cow, right on time. Any questions or comments or anything from the The remote folks?
I don't see any, but please feel free to enter in the chat if you, and
Yeah.
I will be your spokesperson.
You got free lawyer advice.
My question would be, the individual who has the medical marijuana card may view that as a get out of trouble free card because I have the medical marijuana card. You as the employer may not know they even have one until something occurs.
Right. Right, that's why as an employee, I would show up front and let them know. So that way I'm protected. I don't know why they wouldn't share it. Some people are just like, none of my employer's business, right? I have a condition and I don't want anybody to know about it. I'm regulating it. I'm under treatment by my licensed physician or my nurse practitioner, and she's given me or he's given me this card and it's allowed me to take it and I'm fine now as long as I stay on it and use it regularly. So it's nobody's business. But then say I randomly get selected for a test or say I get in an accident and they test me and now I'm positive, boom, show them the card. Well, why didn't you show me this before? Some people have said, if you have a medical marijuana card, you have to, as the employee, you have to tell your employer, right? Because like if you're operating machinery and you shouldn't be operating that if you're under certain prescription drugs because it makes you drowsy or whatever, people will put in their policies, if you are under certain prescriptions and it could have the effect of inhibiting your ability to perform your job, you have to tell your employer. And if they don't do it, could you use that as the grounds for saying, well, you didn't follow policy, we're going to discipline you or discharge you? It's kind of harsh, discharge them, right? I don't know if I would discharge them for that. But you could discipline them. I think that would be fair because they didn't reveal something that was important for them to do their job. But getting back to your original question, yeah, I mean, if they don't tell you and you don't know about it, can you then be liable for discriminating against them? No, because you didn't know.
Didn't know.
Just like with any other disability. If they don't tell you, you can't make a decision based on that. So that's why I'm always surprised when someone doesn't reveal it so that they have that get out of trouble free card.
And one of the questions we usually ask in all of our interviews is, now that you've heard about the position, seen the position description, et cetera, can you perform the essential functions of the position with or without reasonable accommodation? Would you advise or is that leading the witness to say, including medical marijuana cards?
I don't see why not.
To me, that's getting a jump on having that interactive there's
nothing prohibiting you from asking that question.
Okay.
But again, I'm just curious, are you inviting them to disclose a disability? I mean, you're relating it to their ability to perform the essential functions.
Yeah.
So you would treat it like any other disability.
Any other disclosure, okay.
Right.
Well, you haven't lived till you've operated a gas pipeline.
But
PHMSA and the Public Service Commission, if there's anyone injured, everyone at the job site gets tested.
really,
If there's a fire or an explosion, and I've got a list of phone numbers this long, I've got to notify somebody in Jeff City within 2 hours of it happening.
Yeah.
So, yeah, they're pretty persnickety about that stuff.
well, for good reason. They want to investigate it as quickly as they can. So.
And even if you don't have a current pool of employees that would fall into safety sensitive positions, but you just want to access good training for your supervisors or managers. I have experience with JT John Throckmorton with TOMO drug testing out of Springfield, and you don't have to use TOMO for your drug testing program to hire JT to do training. He's done a number of supervisory and management trainings for my employers over the years, and does a great job on both the alcohol side and now the marijuana side. So if you'd like more information on that, please let me know and I can get that to you. Because learning how to see those signs, you can have a bullet point list, but he gets into more depth of the what ifs and even has olfactory examples you can smell that
Nice,
sweet musky you were talking about your
Right.
wife
right,
could smell. Yeah, because this is everywhere now.
it is, it is. It is.
Any other questions before Stephen is excused? We certainly appreciate him coming
I
and
appreciate you having
providing
me.
this information. It's
Absolutely.
valuable.
Thanks for the invite.
Well, and your daughter at Mizzou is going to get dinner, so she's happy
Right, she's
too,
happy.
right?
Yeah.
Anything in the chat, Connie?
So Beverly said, Connie would like that contact, please.
Okay,
So is that something that you can send out
Absolutely.
to the whole group?
I
so
sure
everyone
will.
can have it?
Everybody who's
Okay.
on the call, you'll get an email from me that
Okay.
has that information.
And we'll provide you with a copy of the,
The slides are already in the chat.
Okay.
The PDF is there for all the virtual attendees.
She's on it.
great.
Thank you so
Well,
much.
thank you.
Thank you.
Thank you.
So can we clap?